If we can teach the next generation of lawyers how to embrace not only technology, but innovative thinking so that we can deliver legal services and information to the public more efficiently and effectively, then we'll be able to reach those people who are currently not receiving any legal services at all.
Today on Law Next, a conversation with Andrew Perlman, who is one of the nation's leading thinkers and doers on the future of legal education and the future of legal practice. He's the dean of Suffolk University Law School in Boston, where he's helped drive the creation and development of programs for teaching about legal innovation and technology. He's also been a leading force in national initiatives to shape the future of law practice and access to justice, including having served as chief reporter for the American Bar Association's Commission on Ethics 2020, which was responsible for updating the ABA model rules of professional conduct to reflect changes in technology and increased globalization. And he also served as vice chair of the ABA Commission on the Future of Legal Services, which produced projects and recommendations designed to improve how legal services are delivered and accessed. And he was the inaugural chair of the Governing Council of the ABA's Center for Innovation that grew out of that Commission on the Future of Legal Services. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before I get to my conversation with Andy Perlman, let me first take a moment to thank the sponsors who make this show possible. Now on to my interview with Andy Perlman. Andy Perlman, welcome to the show.
Well, thanks so much, Bob. It's a treat and a privilege to join you. Thanks for inviting me.
Well, it's a privilege for me to have you on this show. And in thinking about this show, there's so many things I want to ask you about, so many things you've been involved in that I've been interested in over the years that I'm really looking forward to the conversation. But let me just begin by asking how you've been doing in this difficult year we've just been through, or we're continuing to be in.
All things considered, I really can't complain. I mean, things are going well for me personally. Going into the office, once a week or so. My family is healthy and safe. And if there's any bright part of all of this, any silver linings, I've got to spend more time with my family and my kids, which has been wonderful. So personally, it's been going well, and professionally, we're all facing the challenge of how to engage in our work in a more remote way. But even that has been going about as well as I could have expected, perhaps even better than expected.
Well, I wondered about that. I mean, you're the dean of Suffolk Law School in Boston, and there must have been challenges for you in adapting over the past year. What's been the hard part? What's been the easy part?
There have been a couple of challenges that I'm happy to say we've been able to address better than I would have expected if you had asked me the question a year ago. One, and perhaps most obviously, is moving a program which was essentially almost entirely residential and putting it online in a matter of days in the spring. And that went remarkably smoothly. We had our faculty really embrace the technology. Many of them had already been familiar with it, but many of them became familiar with it in a hurry. And so we were able to finish up the semester strong. And then over the summer, engaged in a lot of training, add some bells and whistles to what our faculty were able to do. And that has gone well this fall. We've had a mix of both in-person and online classes that seems to have worked well. The other challenge is to ensure that for the in-person component of what we're doing, ensuring that everyone is going to be safe. And we spent, with the university, taking the lead, a lot of time thinking through what that would look like. And we put a plan into place that has worked quite well. That's included masks, obviously, in the classroom, spatial distancing, but also surveillance testing. Every student who's taking an in-person class and all faculty who are teaching an in-person class, as I am this fall, we're all getting tested once a week to ensure that we spot any problems before they arise. And all of those efforts seem to have gone well. We have no evidence of any spread of COVID in our classroom. So those are some of the challenges and some of the ways that we've addressed them.
That's great to hear. Have you been back to physical classes for this entire academic year?
Yeah, so we've held physical classes. It's a small minority of our classes this fall, but we were able to get through Thanksgiving. Post Thanksgiving, we told students everything was going to move online, but our semester is essentially complete by Thanksgiving. So that wasn't really much of an obstacle for us.
So, Andy, I wanted to ask how you got to where you are. I know you were a Yale undergrad, Harvard Law School. You did a clerkship out of law school. You were a litigation associate for a period of time after that clerkship. How did you get into an academic career?
Well, getting into an academic career is not easy, so to say the least. But it was a real passion of mine. I loved teaching. I loved the freedom to write about what interested me, and so I segued out of litigation at a large firm and into academia by getting a postgraduate fellowship. It's becoming more common these days. Columbia had a program where you could teach legal research and writing for a couple of years, also spend some time engaging in research, and then go on the law teaching market. And that was just the opportunity that I needed to really find the time to write, get the teaching experience, then look for a job. And it was right out of that Columbia program that I landed at Suffolk Law. And that was back in 2001. So it's been nearly 20 years.
And as I said earlier, in 2015, you became dean of Suffolk. But even before you became dean, you were, I think it's fair to say, helping to drive innovation in the way Suffolk teaches. And in particular, you were a founder of the Institute on Legal Technology and Innovation at Suffolk. What was that, and what was the idea behind it? How did you come about starting that?
Yeah, I'll give you a little bit of the history, and it kind of relates to my own career trajectory. The first part of my career, first 7-8 years, from 2001 to 2009, was a pretty traditional academic career. I focused my research on legal ethics and taught in that area. And kind of this goes back to childhood. You wouldn't think there would be much in one's childhood that would relate to one's future career trajectory or an unexpected turn. But when I was young, I was really into computers. I had a Radio Shack with a tape deck that stored the information. I'm revealing my age by telling you what I had.
And you're a lot younger than me, so don't worry about it.
And then I had a Commodore 64 and did some, modest programming on the Commodore 64, but obviously left it behind and ended up going to law school and had, a more traditional career, working for a judge, you get litigation, and then you're getting into legal academia. But even in legal academia, my career to that point was fairly traditional. But then it was becoming obvious to me as I was looking around the legal ethics world in particular, that the kinds of issues that lawyers were facing were changing pretty dramatically as a result of technology. And so all of that kind of childhood interest in computers and technology came back to the surface. And I started to write about the intersection of legal ethics and technology. And this just happened to coincide with the ABA's creation of the Commission on Ethics 2020, which you mentioned in your introduction.
Yeah, which was 2009, right?
Right in 2009, right? So it was right as I was starting to see all of these connections and write about them and blog about them. And so that got the attention of people who were putting together the commission. And I was asked to be a reporter and ultimately the chief reporter for that project. And it was all about kind of drafting or redrafting some of the rules of professional conduct in light of changes in technology. So it was a really exciting moment for me to be there as the rules were evolving to reflect all of these changes in the legal profession. And so that, and then not long afterwards, the creation of the Commission on the Future of Legal Services and my role in that really helped me to see the bigger picture about what was happening in the profession and what it was that we would need to teach future lawyers about innovation and technology for them to be successful. So that's a very long way, Bob, to answer your question about the impetus behind the creation of that institute. My predecessor is Dean Camille Nelson, who's now the dean at Hawaii, had the great insight and perspective to create the institute. She asked me to direct it. And it was really the confluence of my interest and background in this work and having a dean at the time who really saw the future as well that led to our initial efforts in that area.
But I think it's helped Suffolk gain recognition as ahead of the curve on teaching law students about technology and innovation. So, I mean, what is the institute? And I know probably more recently you've also launched the Lit Lab at Suffolk. I mean, how are these contributing? Why are these essential skills for law students to be learning?
Yeah, well, our first effort was actually to update our curriculum and add new courses that a lot of law schools weren't teaching. And we created, this happened right before I became dean, so this was like in 2014. We created the nation's first concentration, which is like a law school major in legal innovation and technology. And we started to offer courses like legal project management and process improvement, automated document assembly, design thinking. And we were very fortunate to be able to draw on experts who happened to be in the Boston area, people like Catherine McDonough, Mark Lauritsen. They started to teach in our program. So we were able to put together a collection of courses to create a concentration. So those early efforts got a lot of attention because there weren't that many law schools doing it. And what was really gratifying and affirming that we were heading in the right direction is that shortly after we created the concentration, I got a call from a law firm in the Northwest, Davis Wright Tremaine, and they were looking for people who could pair the traditional legal skills that law schools had always taught with some of these new kinds of skills like project management, process improvement, and they had a legal solutions architect position. And they called us at Suffolk. And I remember Davis Wright Tremaine's in the Northwest. Yeah. We're in Boston, and they reached out thousands of miles to contact us because they told us straight out, we're having trouble finding people with these skills. And they ended up hiring one of our graduates, and then they hired another and another. And then we started getting calls from a lot of legal employers, not only in law firms, but new kinds of employers and jobs that didn't even exist 5 years earlier. And that was really affirming for us that we were on the right track, that this was ultimately going to be good for our students. So the concentration then started to evolve into other kinds of projects. And you mentioned the Legal Innovation and Technology Lab. The idea behind that is it's kind of a research and development shop for thinking about innovation, both for the private sector, because we do partner with the private sector, but also in terms of improving access to justice and trying to create solutions that will improve the affordability and accessibility of legal services to the public, given the dire need that exists. So that lab has then attracted grant support from organizations like Pew Charitable Trust. It's attracted alumni support. We've gotten alums eager and excited about what we're doing. So this is all kind of having a snowball effect of more and more work in legal innovation and technology. And it was really hatched from a very early idea, kind of seeing the intersection of technology and law.
And that's a clinical program. The Lit Lab is a clinical program for students.
Yeah, it's part of our clinical programs, and we have some amazing people working in it. We've got David Colarusso. He's the director of the Lit Lab. We recently were able, and because of the generous support of one of our alums, clinical fellow Quentin Steenhuis, who's doing some amazing work as well in terms of automating documents to allow people to get better access to the courts while they're closed. So it's been great to see some real impactful work taking place on the ground as a result of those efforts.
Yeah. So as I said several times now, I guess in this interview, in 2015 you became dean. And what attracted you to the role of dean? I mean, what did you want to accomplish by becoming dean?
Yeah, it has to be the right fit. I didn't want to be a dean per se. It wasn't that I aspired to be a law school dean, but I felt like I could achieve something at Suffolk in particular. It was a place I knew well because I had been there for 15 years at that point. And I saw the promise of what was in front of us, sort of the early stages of our legal innovation and technology work. I had a vision for where we could go. So I wanted to be the dean of Suffolk in particular. It was only a deanship I had ever applied for, but I thought there was an opportunity to really advance our work in lots of different areas, not just legal innovation and technology. I just feel, I've always felt that it's a gem of a law school that doesn't always get the attention that it deserved. And I really wanted to help highlight and put a spotlight on the great work that we're doing across the board. So that's really what inspired me to to take on the role as I saw an opportunity to advance an institution that I really care about.
So what was that vision? I mean, what did you think was right, or what did you think needed to be maybe changed or modernized in terms of legal education?
Well, I think especially at that time, because this was after the Great Recession, and there had been a cratering of applications to law schools across the country. It was a pervasive problem. And one core initiative that I wanted to undertake was to ensure, number one, that we were appropriately sized given the demand for JDs, but more generally, I wanted to diversify our sources of revenue. I think most law schools are traditionally focused on the JD, and I wanted to have a broader array of offerings that have some other programs that we're offering that's bringing in the revenue. So I really wanted to think more generally about what it is that law schools do and what we can contribute, while at the same time ensuring that our JD program is offering the kind of training that lawyers are going to need in the 21st century to be successful, so that we are as competitive as we can possibly be in a very challenging marketplace, not only challenging for law students, but challenging for law students in getting legal employment. I wanted to make sure we were well positioned in both of those respects.
So I'm curious how the events of the last year influenced in any way your thinking about legal education. I mean, you're Jordan Furlong, who's been, I think, a lecturer. I know he's been very much involved with Suffolk Law School. He wrote way back in April that, quote, the lawyer formation process is breaking down in front of us with regard to everything that was happening around legal education and the bar exam process at that point. More recently, Mark Cohen, a legal consultant, wrote, quote, higher education is confronting an existential crisis and law schools are its poster child. So what are your thoughts? I mean, do you think that the pandemic has exposed any shortcomings in legal education? Do you think legal education will change in any way because of the lessons we've learned this year?
Yeah. First of all, I'm so happy you mentioned Jordan Furlong, because he was also one of those earlier instructors in our legal innovation and technology concentration. So I should have given him a shout out in that answer to that question. But I do think that the pandemic reveals, I'm not sure necessarily flaws, but I would say opportunities for law schools going forward. And I think in two different ways. Number one, I think it's clear that law schools can deliver a sound, highly effective legal education in an online environment. And we are already seeing a number of law schools providing more opportunities for students to take more of their JD online. And Suffolk is one of the schools that recently got acquiescence from the ABA to launch a new hybrid JD program. We're going to be enrolling our first class of hybrid JD students next fall. So I do think that there are ways that law schools can adapt, be more flexible, and allow people to get more of their law degree online. So I do think that the pandemic is going to accelerate those trends. At the same time, I also think that the pandemic has revealed the extent to which lawyers are going to be expected to embrace remote collaboration and use those kinds of tools and be effective while doing so. I've spoken with a lot of lawyers who have law firms who say they're going to have smaller footprints, physical footprints going forward. They're going to expect their lawyers to engage in more remote work. And so I think that law students, the lawyers of tomorrow, are going to need to be able to work effectively in remote environments, but also, as we were talking about before, use the kinds of tools that law firms and other kinds of legal employers increasingly expect and demand in terms of reimagining how those legal services are delivered to clients. So I think the pandemic is putting some fuel on that fire as well.
So there are some silver linings to this in terms of what's happening in terms of education.
As they say, never waste a good crisis. So this seems like one of those moments.
Yeah. What about, I mean, there's been so much consternation this year over the bar exam process. What are your thoughts on that? I mean, do you think that the traditional bar examination and admission process has stood up to the challenges of this year, or do we have need for reform in the way that we decide who's qualified to practice law?
Well, I think we've gotten through this year with some pretty effective Band-Aids, but I do think that there needs to be a broader reexamination of how we license lawyers. I think it's been recognized for quite some time that the bar exam really is not a particularly good predictor of who's going to be a great lawyer, and it has many flaws. And so I think there is now, I am sensing, an increasing willingness to think about new approaches to how we license lawyers. I know that there is interest in Massachusetts in that regard, and I know there is in a number of other states. So what that's going to look like specifically, that's the hard part. When anybody starts to go down this path of thinking about alternatives to the bar exam, coming up with what the alternative is in the particulars is where the challenge lies. But I think for the first time in a long while, states are taking that question very seriously and are looking for answers.
Yeah, and you're not sure what the answer is.
I don't know what the answer is. I have some hunches of what it could be, and should be. That there's going to be some component of really finding a way to assess the skills that lawyers need to be able to practice competently and effectively. And I think there are other ways of, certainly much better ways of doing that than the bar exam. The question is whether you can develop the ways of doing that at scale with so many people who are looking for, licensure, and from many different schools and different environments. And how can you effectively test and assess people's skills outside of the bar exam? We know that there are more important skills that need to be assessed than what's tested on the bar exam. The question is, how do you do it in a way that's fair and equitable?
Yeah. I do want to move on to some of your work in other areas, but before we get off of the law school question, the two things I want to ask you about. One is, you wrote an article last year entitled "The Public's Unmet Need for Legal Services and What Law Schools Can Do About It." What is the role of law schools in helping to address the nation's need for more legal services and more accessible legal services?
Well, what we know is that the traditional solutions to addressing the public's legal needs are inadequate. Statistics regularly show that 80% of people of modest means are not getting access to the essential legal services when they're facing issues like eviction or child support or matters of that sort. And we know that even 50% of average income Americans are not getting access to effective legal services under those circumstances. And what we also know is that the traditional solutions, which includes more pro bono work from lawyers, increased funding for civil legal aid, and the creation of civil Gideon rights, all three of those solutions, which have been tried for decades, have just proven to be inadequate. Not that they're bad ideas, we should continue to push them, but they've just not solved the problem. So coming back to the question and the point of the article, what can law schools do to contribute outside of those three traditional solutions? And in my view, one of the core solutions goes back to what we were talking about before, legal innovation and technology. If we can teach the next generation of lawyers how to embrace not only technology, but innovative thinking so that we can deliver legal services and information to the public more efficiently and effectively, then we'll be able to reach those people who are currently not receiving any legal services at all. And so I think that a key initiative for law schools needs to be helping lawyers understand how they can reach more of the public by embracing these long overlooked skills.
And then one other issue I wanted to ask about. I mean, this has been a year in which there has been a heightened attention on racial injustice in this country. And the legal profession has had a somewhat spotty record in terms of achieving diversity, both diversity among people of color, both gender diversity as well, within its own ranks. So what's Suffolk Law doing to help promote diversity in the legal profession?
Yeah, so there are efforts that we engage in internally and those that we are focused on externally. So when I think about diversity issues, it's certainly about diversity, but it's also about equity and inclusion. So we think about all three concepts, diversity, equity, and inclusion, when we go about our work. On the diversity front, it also takes a number of different forms, right? There's diversity of faculty, diversity of staff, diversity of students. And each one of them has different solutions. So on the faculty side, it's about ensuring that your appointments processes are fair, that you are able to identify any implicit biases that might exist during those processes. When it comes to students, it's about engaging in outreach, creating pipeline programs. Just as an example, we've created a new scholarship for students coming from HBCUs that we're excited about. So there are lots of potential initiatives on that front that just relate to the diversity of the people who are in your community. But that's not enough. You also need to be an equitable and inclusive community as well. And that requires a lot of effort too. And it's not easy, and there's not one answer, but one is, for example, all of our incoming students get implicit bias training. We need our students to understand cultural competence. This year, we're engaged in an overview of our curriculum and seeing if there are opportunities to enhance it with more instruction and background and training in the areas of diversity, equity, and inclusion. So those are just a few examples. And just one more, we created a new position this year, an assistant dean for diversity, equity, and inclusion, who's helping to lead all of these efforts. Again, no one answer. There's a lot of things we need to do all at once. But that's just inward facing, right? So then there's what do we do outward facing to help make a difference. And I think our clinics are part of that. I've been helped to lead an effort just a few months ago as all of these cases of police misconduct emerged with over 50 other law schools. We joined together with the American Bar Association to create a new organization called the ABA Legal Education Consortium on Police Practices. And the idea is for all law schools to work together with the ABA, a national partner, and then in coordination with our local communities and local law enforcement to try to create a national effort that will help give more prominence to a lot of the model policies that, for example, the ABA has created, and bringing it down to the community level. And so one example of what we hope to do is engage in training programs around the country using the 50 plus law schools in our geographic reach to get into our communities and work collaboratively with law enforcement to help expose them to new policies and procedures, to be a training resource, an educational resource going to what we do so well, which is education, but doing it in a way that can make a difference in our community. So long answer to your question, Bob, but those are just a few illustrations.
In addition to leading Suffolk Law School as dean and helping to drive Suffolk's programming in legal technology and innovation, Andy Perlman has also been at the forefront of national initiatives to rethink the regulation and delivery of legal services and on increasing access to justice. More on this after these words from the sponsors who make this show possible. Welcome back to Law Next. In the first part of our interview with Andy Perlman, we focused on his work as a legal educator and as dean of Suffolk Law School in Boston. But beginning over a decade ago with his role as reporter for the ABA Commission on Ethics 2020, Perlman has been a leading contributor to the national conversation on how legal practice should evolve to better address the legal needs of all. I asked Perlman to recap the purpose of the Commission on Ethics 2020 and what came out of it.
Yeah, well, the basic premise was, let's take a look at the model rules of professional conduct and figure out how they need to be updated in light of changes to the profession in the 21st century, with a particular focus on how technology was changing the profession and how globalization was changing the profession. And so there were a number of rule changes which have been widely implemented, and you, Bob, have been great about highlighting some of those changes and how widely they've been adopted. Some of the ones that I thought would get the most attention were, for example, a change to Rule 1.6 and the duty of confidentiality and the steps that lawyers need to take to protect client information in a digital world. And there were lots of new bells and whistles added to the duty of confidentiality. There were some changes to the multi-jurisdictional practice rules regarding foreign lawyers and what that looked like going across borders. But the one that seems to have gotten the most attention, which I don't think I predicted at the time, is the change to a comment to Rule 1.1, which is about the duty of competence. which relates to technology. And this is the one that you've highlighted, how many states have adopted this particular change. And basically what it does is emphasize that a lawyer's duty of competence includes the duty to stay abreast of changes in the law and its practice, including changes in technology, and making sure that lawyers understand the benefits and risks associated with its use. And because it was just a comment, I didn't, and it was supposed to just help people understand what the duty of competence means. I wasn't expecting it to get a lot of attention. I don't think the commission would have said, yeah, that's the one that's going to be one of our defining moments. But turns out that in terms of the Ethics 2020 Commission's work, that's the one I think most people talk about the most.
Right. And I know that I forget exactly which of the reports it was, whether it was the final report or one of the reports that came out at the time, said that was not a big deal because that duty to be competent in technology already existed. It was already implicit, at least, in the general duty of competence for a lawyer. So in your view at the time, you were just putting into words what you thought was already part of a duty of competence, right?
Yeah, exactly. We thought it was implicit, but our focus, our mission was to update the rules of professional conduct in light of technology. And as we looked at the model rules of professional conduct, the number of times that the word technology was mentioned was 0. So we thought we needed to mention technology somewhere. And after some discussion, the commission decided that the best place for it was in the context of the duty of competence. So that's why we added the comment. Yeah.
Yeah. And you mentioned that you thought the more important change perhaps had to do with duty of confidentiality. What do you think it is that lawyers maybe don't understand about that duty even today?
Oh boy, there's a long possible answer to that question. Where they store information, how they store information, how they secure the information. I'm consistently surprised by lawyers who don't know anything about two-factor authentication, which if you're storing any information in the cloud, seems to me, if we're not at the point where it's a requirement from the duty of confidentiality perspective, it's getting pretty close. People don't understand encryption. So there are a lot of what I would view fairly basic protections for client information that lawyers don't really know still to this day that much about.
You were also vice chair of the ABA's Presidential Commission on the Future of Legal Services, which released a report in 2016. Even that seems like a long time ago now, but the report seems so recent in my memory, on the future of legal services in the United States. And that was I think a significant report on the ABA's part, which really provided a somewhat frank assessment of the state of legal services in the country. At the same time, there were some, including me, I think, who were somewhat critical that maybe it didn't go far enough in the recommendations it made. So what was your assessment of the work of that commission and the report that it issued?
Yeah, it was a real privilege to be a part of that effort and the people who contributed to it. It was just a great learning experience, but I also think it was something that has had an impact and raised some very difficult and important issues that need to be addressed. And you're right, we certainly had some people who thought we should have gone farther. But for that moment in time in 2016, I thought it really kind of nicely highlighted the issues that exist with the delivery of legal services in the United States, the terrible problem that exists, and what some of those solutions might be. The one area where I think people felt as though we did not go far enough was in the area of regulatory reform.
Right.
And there was a lot of deliberation about just what we should and could recommend at that time. And what we did conclude is that it was really important for states to consider regulatory reforms without necessarily specifying that any particular reform was worth adopting at that moment in time, but recognizing that regulatory reform was going to be an important part of the solution to addressing the access to justice crisis. So I think that when people thought we didn't go far enough, I think there were some who said, we should have gone farther. We should have said ABS is something we we should do, or something along those lines. But I believe and still believe that when you're producing a report like that, it's first of all important to have at least some consensus, but even more importantly, it's important to have some data behind the particular solution that you're advocating for. And at that time in 2016, although there were a lot of people who said, yes, ABS is going to be the solution to the access to justice crisis, the data on that point was, and to some extent still is, thin, which isn't a reason not to do it. I actually personally am supportive of the efforts that are taking place around the country in this area. But if you're going to put it in a report and say, this is going to be an important part of the solution, I think you need to have some of the data to back it up. And at least then, and like I said, even now to a certain extent, it's not entirely clear that will be the case.
Yeah. One of the striking findings of that report was that it explicitly said that the legal profession itself continues to resist change, not only to the public's detriment, but also to its own. That was more or less a quote right from the report. Mm-hmm. I think one of the criticisms of the ABA over the years has been that it's been complicit in resisting change. And that it's in some ways inhibited forward progress on some areas of regulatory reform. So what would you say to that criticism, or to people who raise that criticism about the ABA?
I think there is a kernel of truth to that, but it's not the whole truth. I've had the chance to work very closely with lots of different constituencies within the ABA. And yes, are there parts of the ABA and either entities or individuals who are very resistant to any kind of change? Yes, to be sure. Like as I think is the case in almost every institution for that matter. But do you find people who are actual advocates of pushing for very strong change? Yes, absolutely. You'll find that too. And I think the report, as you just kind of quoted or referenced, points out that the resistance to change is part of the problem. We do need to be open to other ways of doing things, other ways of delivering legal services if we're going to really tackle the problems that exist. So I do think that the report was bold in a lot of respects in calling that out, though it didn't solve all of the problems and didn't push as far as some might have wanted us to go. I do think that it rightly pointed out some of the challenges that exist. And, there was one particular proposal that came out of that work that set the stage and has set the stage for other regulatory reform efforts, which was a proposal to create model regulatory objectives for the provision of legal services. Mm-hmm. The idea of articulating what are the basic principles we should be thinking about when we engage in regulatory reform. So rather than specifying it, it should be ABS, it should be limited licensed legal technicians or what have you, let's try to articulate what principles should govern our consideration of those possibilities. And that, after a serious debate and opposition, it passed. And the reason that there was opposition to it is people saw this as implying that there should be kind of regulatory reform or other kinds of professionals involved in the delivery of legal services. So people don't focus enough, in my view, on that particular resolution and its significance in signaling that the ABA recognizes that there are going to be other people, other professionals who are going to be involved in the delivery of legal services without specifying the nature of that involvement and what the regulatory reform should look like, but articulating the principles that should govern reform in that area. So I think that was an important legacy of the Commission's work itself, above and beyond the report that we published.
Yeah. There has been certainly a significant uptick in activity around regulatory reform in the years since that report came out. Do you think that legacy is part of what spurred that to happen?
It's always hard to know what's causal, but I hope that it's helped to inspire states to consider regulatory reform. I know that another piece of something that I had a chance to work on with the Center for Innovation is Resolution 115, which in many ways is a natural outgrowth of the report from the Commission on the Future of Legal Services and was only adopted just earlier this year, but goes to your question, called on states to consider regulatory innovations that might improve the affordability and accessibility of legal services. So I do think that there is this increasing recognition at the ABA, right? The earlier report, the model regulatory objectives, now Resolution 115, and in addition, these states that are considering these possibilities, there is, I think, growing momentum and recognition that change is necessary. So, whether the report played a role in that is always hard to say. I hope it made at least a little bit of a difference.
Yeah. It certainly seems that one of the greatest sore spots for many lawyers in particular and legal professionals more broadly has been this question of Rule 5.4 and the ban on non-lawyers having economic interests in legal practices. This year, Arizona became the first state to actually eliminate that ban. And, Utah is, I guess, kind of experimenting with it through its sandbox. Do you have thoughts on what's the right answer there, or what's the right approach to that issue?
No, I don't. I think it's an incredibly complicated subject. And anyone who thinks it's easy, I believe, hasn't really studied the issue carefully enough. I think when people talk about ABS, there are so many different flavors of what that means that I don't think we can paint with a broad brush. What I do think very strongly is that we need to experiment with variations to Rule 5.4 and open it up and try different approaches. I can't tell you which one is best and which one, if any, is really going to make a meaningful difference in terms of access to justice and legal services. But I do think that some experimentation is worthwhile, and use the states as the so-called laboratories of democracy, and see what's effective, what works and what doesn't work, and then reassess. Anybody who says they know what the right version of Rule 5.4 should be as a model, I think doesn't have much data to back up their position. So the only thing I can say for sure is we need to try some variations to 5.4 other than the one that exists.
Yeah. Do you think in terms of experimentation that Utah is taking the right approach on that?
I think it's taking the right approach in the sense that it's trying.
Yeah.
It's experimenting. Arizona too. So I applaud them for trying a new approach. The regulatory sandbox idea sounds terrific. Whether it's ultimately the quote unquote right or best answer, I think that's yet to be determined. But we're not going to know what's right or best until states try something. And that, by the way, was the impetus behind Resolution 115 from earlier this year, was to call on states to try new approaches to regulation, much as Utah is doing, much as Arizona is doing. I think it's gratifying. It's wonderful to see. I think we're going to learn a lot, and I think ultimately the beneficiary is going to be the public.
Yeah. A related issue that's been talked about a lot in some of these reform issues is that of non-lawyers or allied professionals, as some prefer to call them, providing legal services in one way, shape, or form or another. Washington State perhaps kind of led the charge with its limited licensed legal technicians, which in sense eliminated, I guess. But do you have thoughts on that issue and what the right approach should be to that issue?
Again, I'm not going to opine as to what I think the right or best approach is, other than the right approach being is I think we need to experiment with this idea. And the Commission on the Future of Legal Services report specifically mentions that as an area that really should be explored. Yep. So I do think that there is an important role to play for allied professionals in the delivery of legal services. It can't be only about lawyers any more than the delivery of healthcare is only about doctors. There are other kinds of professionals who are involved in healthcare, and I think it's very clear that other kinds of licensed professionals, appropriately authorized and regulated, have a role to play in the delivery of legal services, and it will make a meaningful difference for clients of all kinds.
Yeah. So you're not sure exactly what the right approach should be in terms of the regulation, but you agree that there should be examination of expanding the delivery of legal services beyond lawyers.
Yeah, not just examination, but experimentation. Washington State and others that have tried to create new categories of legal services providers, I think it is a good idea to try to experiment in that area, to try new approaches to innovate with new categories of professionals. So I do think that that's right in the sense that that's what we should be doing, is experimenting in that area.
Yeah. One of the principal recommendations that came out of the 2016 report on the future of legal services was that the legal profession support the aspirational goal of 100% access to effective assistance for essential civil legal services to all persons otherwise unable to afford a lawyer. And that the report made a number of recommendations on how to go about that. But do you think we're making progress, or have we made progress since 2016 on towards that goal of 100% access?
I'm not sure that we have. At least not yet, and not in a meaningful way. That language actually was adopted from a resolution passed by the Conference of Chief Justices. So I think it was very much echoing something that was called for by the Chief Justices of state Supreme Courts around the country. As for whether we have made progress in that area, I haven't seen any data that suggests that we have, which is all the more reason, I think, why we need to try to come up with new approaches, and why this year's call in Resolution 115 for experimentation, not just in regulatory innovation, but other kinds of innovation in the delivery of legal services, which can be just process innovations, rule-based innovations, are going to be so important going forward. We can't just rely on the traditional solutions if we hope to make meaningful progress.
Yeah. One of the things that came out of that report was the establishment of the ABA Center for Innovation, and you were the inaugural chair of the center's governing council. What do you think that center is contributing to the profession? What can you tell us about the work that it's doing?
It was a real privilege and honor to be the inaugural chair of that center. Just amazing people, volunteers and staff trying to make a difference and trying to carry forward what was in that report. So there are a few different initiatives that we undertook during my time as the chair. Just a few examples. Judy Perry Martinez, who ultimately became the president of the ABA, was really instrumental in bringing together a group of law schools and legal services providers to create an app called Floodproof. And the idea behind it was people who were impacted by the devastating flooding in Louisiana and needed to get access to disaster assistance, needed to prove home ownership. And many people didn't have it just because of the nature of home ownership in Louisiana. And so through this collaborative effort, we created an app that allowed people to more easily access the information that they needed in order to apply for disaster assistance. Another one, really, Judy was such a leader behind this, also bringing together the ABA's criminal justice section and a number of ABA entities outside law schools, is a Miranda tool that police departments could use when they're Mirandizing people who don't speak English. And the idea behind it was to have a little device that would speak the Miranda warning in Spanish, which was the first language they used. It sounds so simple, but you'd be surprised that very few police departments actually have the ability to give a Miranda warning in anything other than English. And so we worked with a police department to get that off the ground. Another great initiative was something called Legal Tech for a Change. And this was a way for the center to bring together those in the private sector who would like to make a difference in terms of access to justice and put their technology in the hands of legal services organizations around the country. And so an example here is Marty Smith, who was the vice chair of the center. He has a company called Metager, which is a document management company focusing on small firms. And he was
out of
like,
Seattle, I know him well.
Yes, you got it. And he thought, well, it would be great to put this in the hands of legal aid offices, which would really benefit them in helping find documents that they need so they don't have to reinvent the wheel when they're, creating a legal document of some kind, just as an example. So he did a giveaway and an installation of his technology in legal aid offices. And he said, why don't we replicate this and find other kinds of private sector companies who would really like to put their technology in the hands of legal aid offices. So, and then another project is we created a legal innovation, a regulatory landscape, kind of giving a sense of what was going on around the country. You mentioned Arizona and Utah, a way for people to look at a map and, find out what's going on in terms of regulatory innovation. So there were a lot of great, fun, interesting, impactful projects, and Just really proud to have been a part of that effort.
So I hear you saying that you applaud experimentation and that there needs to be more of that. There needs to be more data on what works and what doesn't. So much of your work over the past decade and beyond, longer than that even, has been on these issues of regulatory reform, on increasing access to justice. Do you have any just broad thoughts on what we should be doing more of to enhance access to justice? I mean, do you have any thoughts as to what the right direction is that we need to be focusing on?
I think the right direction is really twofold, without getting into the particulars, because as I mentioned before, I'm not sure I know what particular form these innovations should take. But number one, we should be thinking about new categories of legal services providers. I do think that's the right direction. What that looks like, what the regulatory structure for them should be, I think those are the devils in the details that absolutely need to be worked out, but that is a clear direction that we need to take. Another one, more generally, is about regulatory reform. I do think some experimentation with Rule 5.4 and other kinds of regulatory reforms that will make it easier to innovate, that's also going to be a part of the solution. And third, going back to something we were talking about before, I think we need to train the next generation of lawyers differently. They need to understand that technology and innovation has to be a core part of what they do. They need to think about how they deliver their services and be able to do it better, faster, and cheaper. The way that I think about it is like this. In law school, we teach law students how to issue spot. You don't take torts necessarily so you remember every doctrine, but you want them, if they see a tort issue later, they know, oh yeah, there is some concept. I can kind of refresh my recollection as to what it was, but it's kind of issue spotting.
Right.
I want the next generation of lawyers to be able to do that with legal innovation and technology, that when they're delivering some kind of service, a contract, a piece of litigation, discovery response, they say to themselves, you know what? In law school, I saw something that said, I bet we could do this in a better, faster, and cheaper way if I just use the right technology. I want them to be able to do that. And I think if they do, they're not only going to be more competitive as lawyers, but ultimately it's going to help the public better address their legal services and make it more affordable. So those are the three general categories and the directions I think we need to go to really make a difference.
And my last question, do you think the last 8 months, 9 months of this pandemic, have they in any way changed your thoughts about how we need to address access to justice or how we should be focusing our efforts on increasing access to justice?
The only way that it's changed my thoughts is that I think that the progress is going to be made more rapidly than I thought would have been the case. Just one simple example, it's born out of the experience we've had at Suffolk, assisting the Massachusetts courts with automating and digitizing a number of their forms to give the public more easy access to the essential legal services that they need while the courthouses are closed. I mean, there was an eagerness, a readiness to accept that assistance and to put it into effect that ultimately helps the public. And I think if it weren't for this pandemic, that would have taken much longer. And I think there are efforts like that taking place around the country. So I think that the pandemic gives me a lot of hope that people are seeing the promise of how technology and innovation can really make a difference in the lives of people who really need those services. So I guess at the end of the day, I'm somewhat hopeful.
And any last words before we wrap up here today? I've been throwing a lot of questions your way. Anything else you wanted to mention or bring up?
No, other than this has been a treat. I really feel like there's so much going on right now in the legal industry, in the legal marketplace, in the private sector, in terms of access to justice, in the public sector, and in law schools. It's really an exciting time to be in the legal profession. So I think the best is yet to come, at the risk of sounding too cliche.
Well, and you've been right at the center of driving it all forward. So congratulations to you on everything you've done and all the accomplishments. And I look forward to continuing to follow everything else you will continue to do. And I really appreciate your taking the time to be with us today. It's been a pleasure to speak with you.
Oh, it's been a pleasure. Thanks so much for inviting me.
Before we wrap up today, let me also give a shout out to our top supporter on Patreon, Alan Rodriguez, the CEO of the legal marketing and digital innovation company 1400.com. Let me remind our listeners that if you appreciate Law Next, you can support us as well at patreon.com/lawnext. And if you'd like to learn about advertising on our show, shoot us an email at info@lawnext.com. This show is produced by Populous Radio. This is your host, Bob Ambrogi. I hope you'll join us again next time for Law Next.